Today I'm going to talk about working conditions, especially the payment issue. As a student, have you ever worked as an intern in the sport organization before? Have you ever worked? Right? Where and when and how long? hmm Okay, so how many hours did you work a week, and how long? How many weeks? The full time? Okay, so did you get paid from the government? Okay, okay. So that's a good to hear because a lot of organization they trying to abuse student labor, especially due to the nature of the sports management domain. Um, a lot of students trying to find some internship opportunity, especially in major organization. But think about the bargaining power. You need to get some experiences before you find a job. Maybe 20 years ago, even 10 years ago, internship was not requirement for getting a job. But nowadays, like 2015, internship can be one of the most essential component of being a competitive candidate for the job, right? So as time goes by, organization taking advantage over the student body who seek out an opportunity. Doesn't matter full-time internship or part-time internship, but they're trying to build up some number of hours per week or a month, because we believe that that will be helpful, definitely helpful when they were interviewed for the full-time job in the future. But think about when I was in the United States, there's a lot of interesting thing happen. Maybe 2005, I just worked in the school of business department, school of business, because sport management was in the school of business, my former institution, and we had two different students. One student majored accounting, and the other student majored in sport business. So major name is a sport business, and they were accepted for internship program endorsed by city of Tampa. But accounting majoring student receive about $10 an hour, and sport business major didn't make any. So we kind of looked at, is it illegal to hire full-time student intern without paying, any money? So what do you think? So same, two student majoring business majors. I mean, obviously there's two different specifications, but same school, same year, juniors, and then same organization they worked on. But one student made money, received some stipend. The other student did not, because she majored sport business. And then that mentality from the employers, they believe, oh, student body is free labor. So that's one of the critical aspect from my perspective, because how can you see my student, my sport business major student, as free labor? They call me whenever they have a bigger or small size event. They call me and ask me, hey, can you recommend 10 to 15 students? Okay, so I don't want to send my student without receiving the job description. What kind of student you want, and what kind of job my student have to do. And then they don't have any job description. They believe they contact all different department in different schools and look for free labors. So that made me pissed off. So my department chair kind of upset. So she wrote a paper, scholarly paper, about, is it illegal to hire full-time student intern without payment. But sport organization getting smarter and smarter, so they try to escape from these harder situations. So I'm going to, excuse me, I'm going to give you one examples how it works in reality. So this actually based on my friends. We studied together at the master's program at the University of Florida, and he majored communication in undergraduate program. So he actually had a lot of volunteer and internship experiences with sports organization in Gainesville, Florida. And after he graduated from the master's program with me, sport management, and he said he got a job. Okay, congratulations. So we have a party. And then his first job he got as a full-time employee was the minor league baseball team, single A team affiliated to Chicago Cubs. So he was originally from Miami, Florida, and then he actually married at the time. Excuse me. And then I asked him, "What's your salary? How much money you make?" And he didn't want to share. And I kept asking, and he just shared the secret. $18,000 a year. So this is a one-year job. $18,000, which happened in 2001. So $18,000 is it good money or bad money? So think about this. This is based on the actual scenario. And after working 3 years, my friends was so lucky. So after 3 years with minor baseball team, and he got a full-time job in Florida Marlins, where he was from. So 3 years of experiences within minor baseball team helped him get a job within Major League Baseball. So after 13 number of years, and he upgraded to ESPN. So he got a job at ESPN, especially baseball specialist. So spring camp specialist with ESPN. So he was one of the lucky and competent, people. But there's so many people who are not treated as supposed, they were treated. And another case. This happened once again about 8 or 9 years ago. I invited general manager of minor baseball team in Tampa area as a guest speaker in my marketing class. And after his lecture, he started recruiting student intern from my class. And he said, this is a paid position. Electricity and apartment will be provided for free. Okay, it has a refrigerator, and then TV, even cable TV fee will be paid by the team. And then each student intern will be paid about up to $400 a month. So this is a single A minor league franchise. So $400. So mostly single A teams last about 3 months. June, July, August. So he looking for dozens of my students. And then after summer was over, my student started complaining about how they were treated from the team. We found out about 10 students shared 2-bedroom apartment. And then there's only one refrigerator. And then think about the summer in Tampa, 100 degree, 110 degree. So there's no space they can put their own food and beverages. And the worst thing was they had to work until 2 a.m., 1 a.m. or 2 a.m. The next morning, they have to wake up in 6 a.m. in the morning. So they were asked to, they were given only small number of hours, in terms of sleeping and eating. So this is abuse of my student. So is it illegal? So as a professor, advisor, what could I do? So there's a limited thing. So I actually jump into find out some of the legal issues within the student interns. And if you have the supplementary materials, so I'm going to give you, actually I printed out some of the articles. This is, if you look at week number 11, and after the PowerPoint, and then can be able to see the report of the unpaid interns. So this is an article. This is a published article about 2 years ago. Okay, so if you have time, please read this case. How terribly the students were treated by major organizations. One of the prestigious case which has been spread out the United States last year was from the student, New York University student. She majoring journalism, and she had a full-time internship position with one of the movie drama makers. And then, did you watch the movie Black Swan? So actually she worked for the company who created the Black Swan. So she wanted to, do some kind of unique, especially something that she couldn't learn from the school. So classroom setting and practical setting. So there's so many things we cannot learn from the classroom setting. So that's the main purpose of having promoting the internship program. So you gotta see and you gotta learn some of the very expensive program or software, right? So there's just some, obviously there is a limitation to let you access that kind of programs or software and experiences. So anyway, after she worked so hard and she came back to school and she realized that this is a free labor. And she realized that she worked as a full-time employee and she didn't get any money, any stipend. And she's one of the leaders in the program. So she complained to the university, New York University, Student Employment Center. How can you post unpaid internship opportunity on the university job bulletin website? Because she found that opportunity at the university website. And she expected university should have screened which is a good one or bad one. And then she argued that university failed to screen and refine some good opportunity only for their students. So Newsweek reporter actually jumped to her and to help her to make it this problem an issue, a national issue in the United States. So she filed a claim. She's not the only one. There's so many different, so many people who believe they were mistreated by the major corporations, especially for-profit corporations. So she won. She won because there are several reasons. So I'm going to explain 6 criteria. If you want to hire student intern, you gotta satisfy 6 criteria provided from Department of Labor in the United States. If you simply hire student intern and assign some of the jobs and duties and responsibility that other full-time employees supposed to do, then you will be violating Department of Labor's Fair Labor Standard Act. In Korea, I think the 근로기준법. So there's just some groups of people should be protected by 근로기준법, Fair Labor Standards Act. I can call it FLSA, Fair Labor Standards Act. So please read this case, and then probably you will learn what's happening right now. So this is one of the starting point, tipping point. More and more smart and experienced interns going to file a claim under FLSA. So going back to this slide, think about, okay, $18,000. That's good. Approximately $346 per week, or $8.65 per hour above the minimum wage. Expecting Korea to work his normal 40 hours in the office. So this should be highlighted. So in the office. So this kind of indicate what kind of job status, what kind of a job category that his job belongs to, as well as conduct promotions at dozens of events during evenings and on weekends. It is entirely likely that Corey could work in excess of 70 hours per week. That's easy, right? So normal days from Monday through Friday, and then when did they have a game? Friday, Saturday, and Sunday. So this is a family business, family entertainment, and targeting the family during the weekend. So Friday, Saturday, and Sunday. So if you're combining 2 more days, then probably working more than 70 hours, that's kind of piece of cake. So which would reduce Korea's hourly wage to $4.94. So think about, if you hire someone on evenings and on weekends, overtime payments, you have to pay 1.5 times that the hourly wages. So can you think this organization, this minor baseball team, hired Corey as a full-time employee because they wanted to save some cost? And from the Corey's perspective, oh, I'm lucky I got a full-time job. This is my dream job, working for minor baseball team. And business card says, I am assistant promotion, marketing and promotion manager, with my name on, my office number, right? So family will, support it, fully. And friends say, oh, you're a successful man in sport industry. So they envy, they jealous, right? But in reality, if you look inside, excuse me, the reality, and truly, he's just making this is clearly below the minimum wage. So do you think this can be fixed by law? Okay, let's take a look at. So this is the first case that we're going to attack. Two major issues that we're going to cover this lecture: employment, employees' compensation. How much you make? Do you get salary? And if so, how much do you make? And what types of job do you work on? And then workers' compensation for work-related injuries. Work-related injury, in Korean, 산재. So last week I just watched Korean newspaper. Korean TV news, and there's some accident. A couple of employees injured while they have a 체육 행사 during the weekend. So everyone has to go. They were forced to attend one of the once a year entertainment or sports activities. Who initiated? Initiated by the company or CEO. So if you injure while working kind of a soccer game, so who's going to pay for it? All the medical bills? Out of your pocket or company? So that's the topic. So how do you see? If you injure some of these sporting event, then who's going to pay for it? If corporation or company should pay for it, based on what? What rationale? How can you see this is a extension of your work? So, we can hear so many cases, similar cases, one of the marketing manager was forced to play golf on weekends, not for fun. So this is a kind of a hospitality. I'm going to treat my uh, buyer, right? So try to make them happy as much as possible. But golf is one of the very common hospitality event. So they can invite, but think about when do you play golf? Saturday or Sunday? Because Monday through Friday they're so busy with working. So if you injure by playing golf on Sunday, this is a work-related entertainment, right? Then should company pay for the medical bills? I mean, worst case scenario, several employees died after golf tournament. I mean, golf event, because they were forced to work on weekends. How many hours do you work? I mean, this is not sports. I just want to play golf with my friends and my family, right? That's for fun. But I don't want to play golf with some work-related, employee, or out of my job. So jury's perspective, judge's perspective, they have to make a decision. Oh, if it's job-related or employment-related, so if they believe it's so, then corporation or company should pay for the medical bills. Okay, but it's not simple to clarify. Is it job-related or is not job-related? So that's the second major issue that we're going to cover. Okay, Department of Labor. So I'm going to skip this part because you don't have to remember. So you have to be familiar with Korean Department of Labor. But the main purpose of this class is to introduce some American law, right? So competitive law in sports and leisure activities. So we can call it like a 비교법. So we don't know, what direction we're going to. Then we can take a look at some Japanese law or German law or American law. But anyway, so you don't have to remember this number. Not that important. But I just want you to understand the four underlying issue. So this is a still important issue in Korean, the context of Korea. The minimum wages. So we can call like a passion 열정 pay, passion wages, whatever you call it, whatever you interpret in Korean. But minimum wage is one of the key issue that we have to consider. So Fair Labor Standards Act. I think this is a 근로기준법, Fair Labor Standards Act, FLSA. So when I say FLSA, I want you to think this is a Fair Labor Standards Act. It's an overtime pay. So if you work more than 40 hours a week, then you deserve get overtime pay. And record keeping. So this is a mostly non-salaried employees. I'm the salaried employees. If I work more than 40 hours a week, 40 hours a week, I cannot request extra money because I'm salaried. But if you work hourly basis, so if you work some convenience store and then you work 40 hours a week, then probably you can request 5 extra hours. Or if you work 5 extra hours on weekends or after your work hours, then you can request 1.5 times that your hourly wages. And record keeping, so company or employer is responsible to maintain their log sheet, such as what time do you start working today, daily basis. Okay, I start working 9 a.m. What time do you get up? 5 p.m. or 6 p.m. So you have to maintain. You have to keep the record, especially for hourly employees. And there are also child laborers. So I don't know them. And then does not regulate vacation. So they don't get. The government is limited to intervene the corporation's business in terms of a vacation. How many holidays do you offer to your employees? That's case by case. There's a clearly none of the government business, so that's up to you. And meal or rest period, holiday off, same thing. And pay raises or fringe benefit. Fringe benefit, kind of extra benefits such as insurances policy, or some of the extra benefit, kind of providing the shuttle buses to the employees, or providing some barracks like a dormitory for the employees. So that's the kind of extra benefit, cannot be touched by the government. And a discharge notice. So I think in Korea, the employer should inform the employee in about a month in advance. Okay, so you have to leave, within a month. So 30-day notice, that's kind of a typical, but discharge notice cannot be controlled by the government. I think it can be different by company. Yeah. So I mean, I think 30-day notice is kind of typical. So when Attorney Kim, Mr. Kim, came to this class, and then he believed that some people will be upset because they were not informed in terms of their discharge, in a reasonable time. So kind of they're upset because they asked me to empty my space, my desk right away. So that can be potential legal litigation issue. But I don't think every company has the same period of discharge notice. But as far as I know, then usually 30-day notice, especially for companies. Yeah, salaried employee, and then 30-day notice. For my former employees in the United States, Gonzaga University, we have a different rules. So if I had to leave, because I was accepted from Hanyang University, so I have to let my university know. But university says 90-day notice. And some universities has a 60-day notice, because they have a reasonable time to hire the replacement. Yeah. So I experienced several different discharge notice, but it's not strictly controlled. They try to understand my situation because I was offered right away, and then I have to think about. But there's so many limited time to let them know, which means I had to violate 90-day notice rules. Right? But they try to understand some of the situations. Okay, so FLSA trying to cover as many employees as possible, but there's a clearly two separate standard enterprise coverages. So if you're doing your business with more than $500,000 asset, by $500,000 business transactions, and then you will respect FLSA, or at least, if you have at least 2 employees or more, then you have to respect FLSA. Such as my friend running smoke shop, 담배 가게 smoke shop, and he has only 1 employee. If it's the case, okay, he will not be affected by FLSA. However, in terms of how much money he handles a year, or individual coverages, interstate commerce, or the production of goods for interstate commerce. He sells tobacco products, okay, import, okay, from other countries or other state. So because of individual coverages, most of the businesses will be or should be covered by FLSA. Does it make sense? So for enterprise coverages, if you handle more than $500,000 or more than to employees within your organization, then you have to respect FLSA. So if I'm hourly work and then employees and they work for the company whose business transaction is more than $500,000, or I have more than two colleagues within my corporation, then I will be covered by FLSA. Or if I work in a smoke shop, for example, if I'm the employee, I actually make based on how many hours, hourly basis. Then, I'm the only employee. And then my smoke shop actually handles some interstate commerce. And he also sells soda, Coca-Cola and Pepsi-Cola product. So where does it come from? So other state. So and receive some product from other state and sells it in Washington State. So because of these coverages, and he has to respect FLSA. And I think this is also happening in Korea. Maximum working hours, 40 hours set. And minimum wage varies. Hourly employees working more than 40 hours, obviously you deserve to get paid 1.5 times normal wages. So if you work 45 hours a week, then you can make up to 40 hours based on your average hourly wages. But 5 extra hours over 40 hours a week, then you can request 5 times multiply 1 point times. That will be your extra pay for your extra work. So cannot waive right to overtime pay or agree to work more than 40 hours. So no matter what happens, no matter what organization you work for, then you can secure this as a privilege. So this is important because I'm going to come back to Corey's case, the example, but I have to explain, some of the things before we attack the case. White collar exemption. So white collar exemption, any employee in a bona fide executive or administrative or professional capacity on outside a salesperson will not be protected by FLSA. So main purpose of FLSA to protect some employees who work hourly basis. So if you think about some of the examples. So if you work at the McDonald's, okay, if you're not full-time employees, hourly basis, then you will be protected. But if you work like a professor is one of them, we won't be protected by FLSA. 45 hours. I mean, if I work like 90 hours a week, I'm not able to request extra pay. And then the record keeping is not necessary. Because, these are some of the examples. Executive, president of the company, head of the major division of any enterprise, administrative personnel director, vice president of operations, head dispatcher. When I say professional, so this is from the Department of Labor's perspective. So any job which requires some kind of certification. So if you want to be a physician, you have to certify it, right? You have to go to medical school and pass the exam. And attorney, American bar exam, and CPA, and architect. Some of these special jobs require some certification or specific education or degree. Then those groups of people will not be protected by FLSA. They don't have to be protected because they already have privileges such as like this fringe benefit. They have all the benefit. Bigger organization provide more fringe benefit, education benefit. If you go to school, then some portion of the education fee will be paid by the company, right? That's one of the examples. So what else? What other fringe benefit can you think of? Insurance, obviously. Insurance. 4 major insurance will be covered by the company. Yeah, transportation. Yeah, use of some facilities, right? Recreation center or fitness clubs, or some kind of coupons, or if you work for some organization, and they will be provided some kind of credit card, which have some benefit, like a 5% discount whenever you go to shop, you know. And greater job security. So this is the main reason, greater job security. Most of the administrative or executive or professional jobs, okay, have some job security. If you want to fire those people, then you have to, I mean, case by case, it varies organization to organization, but they have to inform the employee or some employees in certain time in advance, 30-day notice or 6-day notice. So they have more time to find a job, right? But daily basis, kind of hourly salaried employee or who does not belong to the organization, okay, they don't have any job security. If employer says, okay, you're fired, then you know they are fired, they're jobless right after that. So trying to protect some people who doesn't have greater job security will be protected by FLSA, but executive position, administrative position, or professional positions will not be protected by FLSA. And better opportunities for advancement. So employee in McDonald's restaurant, they don't have any opportunity for promotion or advancement. So this is why some certain kind of jobs will not be protected by FLSA. Do you have any question or any other examples? Comment? Okay, so we have to review 3 tests if employer, the minor baseball team who hired Corey, violate FLSA, Fair Labor Standard Act, 근로기준법. The first test will be salary-based test. Number 2, salary test. Number 3, duties test. What kind of job does he have? So as long as at least one of these 3 tests are satisfied with Cody's case, then the employer is violating of FLSA. Okay. So, question here. So from the Cody's case, what does he want? If he is not happy with his salary, then what does he want? If he file a claim against the employer who hired Corey, then what does Corey want from the lawsuit? Overtime pay. So he complained about he has to work for 70 hours. So he enjoying what he's doing. However, he believed he deserved more salary than $18,000. So that is the main reason. So most of cases related to FLSA is about overtime payment. Okay. So that's what he wants, overtime payment. Number 1. So salary-based test. Does he receive salary? So once again, if you receive salary, then you won't be protected by FLSA. Does he receive salary? Yes. So even though he doesn't make a lot of money, but he's receiving salary, doesn't matter how many times he received from the organization. Maybe every 2 weeks, or once a month, or every 3 months, doesn't matter how often he receives salary. However, as long as his contract based on the salary, okay, 1 year or 6 months, this is the amount of money you can receive from our company, then that's the indication of salary-based employee. So we have to pass because he receives salary. What about number 2? So this is about how much money, how much salary do you make? So the amount of salary must meet a minimum level. So under the new salary passed in August 23rd, 2004, the employee's weekly salary must be at least $455, which equates to a minimum annual salary of $23,660. So he's supposed to, doesn't matter how many hours he worked, but the minimum salary a week, and then the number of hours, 40 hours, then he's supposed to make at least $455. Then he deserved to make $23,660 minimum. So what can you say? That's right. So his team violating Fair Labor Standards Act because of salary test. But if he received $23,660, then he cannot complain. And then what about number 3? Duties test. What kind of job does he have? According to his contract, I told you in the scenario in the first page of your slide, he has to work 40 hours in the office, right? However, he was asked to work outside his office during the game. However, main job supposed to be done in his office. So based on the job description, his duty kind of similar to administrative positions. However, in reality, this doesn't happen. Not many couriers in the world. Why? 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 Why is so little, so few couriers around in the world? Think about the real perspective. If you file a claim, your employer, then reputation, right? Your name will be absolutely. And most importantly, if you want to promote, you want to find a job in a better organization or bigger organization in that same business, then you need a recommendation letter or you need a reference letter. Future employer will call your supervisor. How was he? Okay. And then you don't have that kind of a relationship. So that's one of the realities. So there's a few cases available so far. So week number 11, can you see a couple of cases? Right next page of interns and volunteers. So after that, after that, 2 more pages. Okay. So yeah. So first court case involved in SETA-WHYU. So I'm going to share this slide with you. So this is it. So first case, for question case involved in Sarasota-WHYU. Sarasota located in Florida State. Sarasota-WHYU is a minor league baseball affiliation of Chicago White Sox. And groundkeeper, he was a groundkeeper, runner Jeffrey, groundkeeper employed by the team. And Jeffrey had worked for the Sarasota-WHYU for a number of years and sought overtime wages. Okay, so they're looking for some overtime wages. Performed since the beginning of his employment. In the light of team schedule, he had to put in more than 40 hours weekly on several occasions, receiving the same compensation for those weeks as for others. The team claimed that FLSA's seasonal or recreational establishment clause exempt it from overtime wage requirements. So based on 3 tests, salary-based test, salary test, and duty test, it seems like the team is violating of FLSA. However, in reality, sports organization, especially minor league baseball team, have some special protection from FLSA. Okay, so that's I'm going to cover. Even though this is kind of clear case, but organizations are smart. So I hate this exemption, but because of this exemption, Corey cannot receive any overtime payment. So we can call it seasonal and recreational establishment. Seasonal and recreational establishment, as the title indicate, if your organization operate less than how many months? 7 months, then you will be exempt. You will be exempt. So if you hire your attorney will say to you, okay, there's no opportunity. There's no way to make a case because they are protected by seasonal and recreational establishment. This is for fun, right? So AAA is one of the longest season sports and entertainment program. Last about 6 months. 6 months from April, May, June, July, August, and September. And AA probably 4 to 5 months, and single A and rookie league last about 3 months. So the law protect the employers. We understand you don't make much money, so we understand if you hire interns for free. And then if, just in case, if your organization operates more than 7 months, if you pass this exemption, your organization operates about 7 months and 2 days, then you have to meet FLSA requirement. However, there's another test. If you operate 7 months, more than 7 months, then let's take a look at. Requires that establishment illustrate its average income for any 6 months of the previous year did not exceed 1/3 of the average receipt for the other 6 months. So let's say your 6 month, the total receipt of 6 month operation last year was $18,000. Okay, ticket sales and all the revenue, $18,000 divided by 6 months. Average, you made $3,000 every month for 6 months for your operations, right? But what about two-third, month income, 2 month income during the rest of the 6 months should be bigger, which means you don't have to worry about it, which means simply if you make some good money during non-season, non-business season, then we have to consider you as a yearly operated organizations. You said you only operate 6 months. How can you make a lot of money during the off-season? But if you prove that, oh, you just operate 7 months, however, during the non-season, especially October, November, December, January, February, our income is limited, very small, then they will be protected by FLSA. That's what it is. But this is a very United States specific guideline. However, technically, if you make a lot of money during the off season, then okay, there's no way the FLA can protect your organization. So 최선준, can you understand? Make sense a little bit? So 7 months rules. So if you're less than 7 months, and then if you operate more than 7 months, let's say 9 months, then you have to prove that during the off season, the revenue of not off season will be very small. Yeah, that's right. So in this case, who won? The minor league baseball teams and minor league hockey teams super abusing these exemptions. So they really happy. However, what about major league team? That's one of the issue. Major league baseball team. And what about NBA? So there's a case. In next, 최선정, you have a supplementary materials. Then there's a next pages. There's another case. Liger versus New Orleans Hornet NBA limited partnerships. 2 pages after, yeah. Two pages after. So this is a new direction in this matter. People are getting smarter and smarter. So the final decision came out in 2008. Okay. So let's take a look at the fact. The plaintiff filed this action on May 27, 2005. The plaintiff are former employees of the Hornet NBA franchise, are seeking compensation for allegedly unpaid overtime wages. Once again, they look for overtime wages that they could have made. The plaintiff worked in the business enterprise of the organization, specifically in sales and fan relations. I mean, that's one of the typical internship positions, right? A lot of the students actually wanted that kind of job. Under the Fair Labor Standards Act, under FLSA, the maximum work week for an employee of an enterprise engaged in commerce is 40 hours. And if an employee works longer, he must receive overtime compensation at a rate of at least 1 and 1.5 times his regular rate of pay. The Hornet argued that they were, so this is a little bit different, right? Seasonal and recreational establishments. But this case actually says amusement or recreational establishment which is exempt from overtime pay and minimum wage compensation requirement. Make sense? So this is one of the few cases actually handle these situations. So holding, the court held that Hornet were a year-round operation. So it's not 7 months operations. So this is a new decision. So because of this case, every student intern, every employee who working for NBA franchise or Major League Baseball team should receive overtime pay. And then this could not qualify for the abusement and recreation exemption. So I'm going to explain, because they're going to actually look at two criteria. How many months do you operate? NBA. The preseason starts September, October, November, December, January, February, March, and April. And postseason, May, and the final game in June. So they operate about how many months? 9 to 10 months, right? So based on the fact, okay, they operate more than 7 months. So they actually have to look at the second one. How much money do you generate during the non-season? Okay. So actually, okay. So the B, let's take a look at B. During the preceding calendar year, each average receipt for any 6 months of such year were not more than 1/3 of each average receipt for the other 6 months of such year. Okay, so you don't have to worry about it. I can summarize this. Based on number 2 factor, they made a lot of money during the off season. How? This is NBA. They sell the season ticket. When did they sell season ticket? Before the season's over, season start. So if the season preseason start in late September, then they start printing tickets about a month ago, so August. So once they have a schedule, they're sending out all the season ticket opportunity to the potential fans and existing fans, right? So if they decide to buy season ticket, then all the money, revenue coming to the team during the off-season. Make sense? What about sponsorship and media revenue? Who broadcast? How much money? Okay, when did it happen? During the off-season. Okay, so during the off-season, your revenue is so great. So we have to agree that you are year-round operations, not a seasonal operations. So you cannot apply seasonal and recreational establishment to your case. So you won't be protected by FLSA. In other words, you have to pay overtime payment to your interns and full-time salaried employee. Once again, if you make salary from the organization, you are not covered. Okay? If you work based on, you actually make based on number of hours, 40 hours, then you will be covered by FLSA. So from this case, think about the plaintiff is not salaried employed. He or she only makes the number of hours that he work. And he believed that he worked more than 40 hours. And that he believed he deserved the extra number of hours over 40 hours must be 1.5 times. Okay, so this is a major difference between United States and Korea. So a lot of a convenience store owner in Korea, they violate 근로노동법 a couple times. What kind of penalty do they get? Not serious. Okay. Maybe fines, 벌금, and probably maybe a certain number of days of close your operations. Right? What about in the United States? I just want to clarify potential first potential imprisonment, possible imprisonment. You can serve in prison up to 6 months. So this is not the misdemeanor. This is a potential felony. You have to serve in prison. So that's that's big. So try to protect your employee who does not receive salary.